Thanks for joining us today. My name is Jessica Schneider. I'm CLE's managing attorney and manage our pro bono programs. This is the first seminar of our 2021 virtual pro bono CLE series, and this will be part 1 in February and March. Another quick note, please try to match your name on your Zoom screen for making it easier for us to keep track of you for CLE purposes. We'll send out materials afterwards and another link again to fill out the evaluation, which is another easy way for us to track your attendance. And then you should get your certificates within a week or so. You can ask questions during the seminar in the chat, and I will keep track of that, or at the end of the session. Just a little bit about our pro bono program. CLE's pro bono program works to increase the availability of pro bono legal help for those who cannot afford an attorney in Illinois. We do that through developing innovative pro bono opportunities, offering pro bono programming and resources like this one, and cultivating best practices while also recognizing pro bono. And that is partially through the work of our judicial circuit pro bono committees, which strive to increase equal access around the state to justice and promote and enhance pro bono legal services. As many of you probably already know, there is a great need for pro bono assistance in family law, and specifically with protective orders, which we're talking about today. So we are here to discuss that need and also make sure you know about the opportunities to get involved. First, we'll hear from Caitlin Isbell. Caitlin is a graduate of Southern Illinois University School of Law. She currently works at Land of Lincoln out of the Eastern Regional offices in Charleston and Champaign, and practices family law in the 4th and 5th Circuits, representing clients who identify as victims of domestic violence in civil matters, and so she can help victims secure their independence from their abusers. She also is the co-chair of the Family Law Task Force at Land of Lincoln and the pro bono coordinator for the 5th Circuit, and has joined our 5th Judicial Circuit pro bono committee. And then from the perspective in the northern half of the state, we'll hear from Kathy Betcher, who is the Director of Family and Survivor Advocacy, is located in the West Suburban office and supports the attorneys throughout the offices doing family and survivor advocacy. And we have a pro bono volunteer with us, David Ryan, who has been a volunteer at Land of Lincoln for many years, taking on family law cases and continuing to volunteer after he retired at the end of 2018. He takes plenary order of protection cases, contested or not, and can offer that perspective. And last year received the 5th Judicial Circuit Pro Bono Service Award. So now I'm going to turn it over to Caitlin to get us started talking about orders of protection. Again, any questions, feel free to put them in the chat during the course of the presentation.
Okay, I believe, Jessica, I shared my screen. Is everything good?
Everything is good, yep.
All right, fantastic. Like Jessica said, my name is Caitlin. I'm from Land of Lincoln Legal Aid. Today, I'm going to be presenting on civil protective orders. I'm going to assume everyone has a basic understanding and knowledge of orders protections and civil protective orders. My goal here is to do a little bit more in depth of trial tips and things to look for when litigating these cases. If you take some of our pro bono cases, if you're not familiar with them that in-depthly. I'm going to skip around here and there because we have a limited amount of time. I know most people are probably on their lunch listening to this. So Jessica's going to make sure that everybody gets a copy of the PowerPoint for them to review later that has more in-depth information. Just as a disclaimer, out of habit and for clarity purposes, I'll most likely refer to the victim as a female and the abuser as a male. I represent both genders. I've gotten orders against females. I've gotten orders for males. I don't recognize that all abusers are men and all victims are women. But I just wanted to kind of get that out of the way in those two housekeeping matters. So the types of orders we'll be discussing today are the civil form order of protection, civil no contact orders, and stalking no contact orders. The big thing I want to point out with these is I tend to see people discuss civil no contact orders and stalking no contact orders interchangeably as if they're the same order, but they're actually two different acts. I've provided the links and the acts to all three for everybody to reference later. The first one I'm going to discuss is order of protections. That's the most common that you would see if you're going to take a pro bono case. That's the ones we get the most often. They're the ones I would want to litigate the most for clients because they have the most options for remedies. A couple practical tips. I'm not going to run through each part of each type of order. I have them up here on the screen. A couple things have changed for service purposes to check on judici to see if a respondent has been served or not. You're not going to get to see if it's live on judici, that means the respondent has been served notice of the plenary order of protection. Prior to that, is not going to show up on any public forum that the order of protection has been filed. So you're going to have to call directly to the clerk's office to see if summons has been successfully served if it's not live yet on judici. Also, when it comes to publication service, I advise my clients that we need to at least try to go for at least 2 alias summons prior to going for publication. I just think judges are really hesitant to order publication because odds are that respondent really is never going to see that publication in a newspaper. Also, if you're representing our clients, odds are the county would be covering the cost for that publication. So we really want to see a diligence in trying to get that respondent served before resorting to publication. A big thing with civil no contact orders, and really all 3 orders I like to point out for other attorneys and pro se litigants, is age doesn't matter when it comes to filing for one of these. A 15-year-old or a minor can file for an order on their own. A guardian does not have to. Also, it doesn't have to be a relative. It can be a coworker, it can be a friend that would file on behalf of somebody. I would just take note that if it's not somebody filing on behalf of a minor or somebody under the age of 21, or they're not filing on behalf of an elderly or disabled person, I would have some concerns on why the victim isn't filing on behalf of themselves. I would be concerned about cooperation and how smoothly is that case going to work if the victim isn't advocating for themselves in that matter. A big thing with civil no contact orders is there's no monetary remedies available, unlike stalking no contact orders and orders of protection. Your stalking no contact orders is the toughest type of order I think you're going to see, just because it's a harder case to make. That usually means no physical violence, and it's a lot of harassment and emotional distress. On occasions, I have to remind the court that harassment is presumed by the act. Certain actions are presumed to be harassment. So even though myself or you may not think it's that big of a deal, if he showed up to her work a few times, or he's calling her voicemail, leaving her a bunch of voicemails repeatedly, or continues to show up in public places where she's at, those acts themselves are presumed to be harassment. And so I don't need to rationalize if they are harassing or not. There are monetary damages are not available in stalking no contact orders, but you can request attorney's fees and court costs in the stalking no contact orders. Sorry, I forgot to click. Keep you guys going. With a couple of things I want to note with when you're arguing your emotional distress portion, I see respondents, petitioners in pro se cases, and I see often, I had to learn this myself, I see attorneys forget to meet the elements in emotional distress, that it's a reasonable person would experience emotional distress, and that the petitioner did experience emotional distress. So after you're going through an allegation on the stand in your testimony, I always make sure to follow it up. So we've gotten the facts of what happened, but we always ask the petitioner on the stand, and how did that make you feel? So then she can explain to the court, she was scared, she was anxious, she didn't know what was going to happen. So then you fulfill that final requirement of emotional distress. It may seem obvious, but I see it repeatedly being skipped when I'm waiting for my case to be heard. And it's a trigger for judges, I think, sometimes to just go ahead and deny those because they can be so complicated to order sometimes. The next two slides is where I'm probably going to spend the bulk of our time here. It's just a few tips to think about with your cases. If you take some of pro bono order of protection cases, or if you have order protection cases you're handling on your own, just from my experience in these, there's some stuff that you may have not thought of or might think of doing it in a different way. I always go to these things hoping to pull out a couple of things from them that I can use in my practice. So that's kind of my goal here to you. Take it for its worth. It's 100% my opinion. Nothing based on fact. But I often see, the first thing I often see is people not taking advantage of Freedom of Information Acts and going straight to subpoenaing information from police departments. I do it for two reasons. I love Freedom of Information Acts because I tend to get a lot more than what I could get out of a subpoena, which you wouldn't think would happen, but it usually just goes to administrative assistant when they get it in the mail. And I've gotten everything from body cam, dash cam, interview footage, pictures, reports, a whole slew of stuff to where I can get, they'll turn over really limited things from a subpoena, or they'll direct me to go deal with the state's attorney's office because they've already turned it over. I also go for a FOIA when the client is not very clear. I have a lot of questions after I've met with the client of what exactly went down that night and the police department was called. Domestic violence aren't very trusting starting out from the very beginning, and they're not going to be forthcoming with a lot of information at the very beginning. So if I think I've pushed them as much as I can push them right now with getting information, I may do that FOIA request if I know the police department was called, and just kind of see and fact find and see what turns up and sees what the report from the officers were of what happened that night. So I can get a look from that side. Also, you put it in your back pocket from notice. You file that subpoena, you put the other side on notice that you're trying to seek something specific. I do a FOIA request. If something comes up out of it, I get pictures, injury pictures or something like that, or broken, damaged property photos the client didn't have that she reports, like, well, they took pictures of me, of my injuries, but I don't have them myself. You can get them that way, so you can use them at trial. And unless they ask for it or bring it up, you don't necessarily have to hand it over. Especially with your pro se respondents aren't going to know. A big thing I had to learn doing these over time, and I see this often in court, is to make sure you remember the petitioner is not on trial. I think the respondents often try to rationalize their behavior with the bad behavior of our clients. And I often have to object multiple times that her accusing him of cheating or he cheating or X, Y, and Z happening does not rationalize or give a pass for punching my client, throwing my client through a coffee table, throwing her out of the car, etc. It's not what led up to the act, but what is the bad act that happened. I'm often objecting to that. I think it's easy to get distracted and get defensive of your client when really you just got to shut it down from the very beginning because technically it's not relevant. Also to make sure that, and we'll address this in a little bit, but make sure that the client really gets across the risk of future harm besides just meeting the basic elements of what the IMDVA requires. To show the judge and the court that without this order, this is only going to escalate and get worse, or he's not going to stop. And that's why we're here and we're resulting to this point. When it comes to presenting cases, I think orders of protection are, I think it's kind of common knowledge, they're not the court's favorite things to hear sometimes. They can get really dramatic, they can get bogged down, especially when you have pro se litigants, they can get chaotic. So I try to get in, get my points across really quickly and get out. I think the courts really appreciate it. And so I do that with my clients. I do that with my witnesses. My witness is there, I get my foundation out of the way and go straight to what they're there to talk about, and I get them off the stand. And I explain this to my clients that I pick one of two routes when it comes to crossing the respondent, especially if they're pro se. Pick your battles. Most of the time, if they're pro se, they're going to get on the stand and they're going to get to testify in the narrative to their side of the story. Well, most of the time, they don't say anything really worth anything. They get up there and ramble, they'll rationalize, and often they forget to even deny anything that our client accused them of on the stand. And so by me crossing them, I'm not going to get what I want out of them, right? I'm not going to get the you can't handle the truth moment from them. So I'm not going to waste the court's time, and it's really going to do a disservice to my client if I start to muddy the waters by trying to cross them, if I'm not going to get anything out of them. Or the only time I will cross them if I think they said something really egregious that I do have that I can get them on, or if they contradicted themselves or admitted something in their narrative that they didn't even realize they did, then I may reinforce it on cross to point it out to the judge. But I keep it really limited, quick and brief, and get them off the stand as quickly as possible, because usually they don't have other evidence, they don't have other witnesses when they're pro se, so then you go straight to judgment. And often I hear the judge say, I heard a lot of X, Y, and Z, but really at no point in time did I hear the respondent say he didn't do these things. And so that's why they end up entering the order. I've also seen respondents, opposing counsels, get really distracted about trying to paint the petitioner as the bad guy, that they forget to have their clients deny the allegations the client made on the stand during our case in chief. Just a couple things to think about there. My favorite thing to use in order of protections and civil no contact orders and stalking no contact orders is judicial notice. I use them every single time I can. I don't think enough people use them, and especially attorneys that aren't familiar with order of protections in the IDVA. Propensity evidence is admissible. It specifically states in the statute that when a judge is trying to determine whether to grant specific remedies other than payment of support, the court shall consider relevant factors, including the nature, frequency, severity, pattern, and consequences of the respondent's past abuse, neglect, and exploitation. I think the best evidence for this is pending criminal charges and convictions. I do it in two different ways. If it's a pending criminal matter and the respondent is pro se, I will do it as a housekeeping matter right before we start the hearing. When the judge asks if we're ready, I'll inform the judge there's a pending criminal matter. I'll give them the case number, request he takes judicial notice of it, that those charges came from allegations that were within the petition that's going to be discussed today in this hearing. Any request that he admonishes the pro se respondent. It's a twofold. It helps you in the fact that a lot of times pro se respondents will throw in the towel right then and there. They'll just say, I'm out, I don't care, I agree to it. And now you're done, you don't have to go to hearing, and your client doesn't have to take the stand. The other way, if they still want to contest it, it kind of sets a tone before your client's even gotten on the stand. We've already got these criminal charges that had to have enough probable cause to arrest them and charge them. So there's already an uphill battle for your respondent. If it's a case outside of your county that you're doing the hearing in, so your client may have fled to this county and is filed for the OP, but the charges are in a different county, I always get a certified copy from the clerk's office and present the copy for the judge when doing anything regarding judicial notice. If they're big charges, I'm talking your felonies, usually I always consult with the prosecuting attorney if they have any concerns about the victim testifying. The ultimate goal usually for your clients is, I mean, they go to prison and they're safe, right? They don't have to worry about their abusers popping back up. So I like to touch base with the prosecutors to make sure they don't have any reservations about it. Usually they don't. If anything, sometimes they want to be present and kind of watch to see if adverse says anything they need to take note of or anything comes out that they may need to investigate more on. And at a minimum, they're going to pull the transcript from that hearing. If it's a judicial notice for past violent crimes, I emphasize on violent crimes. I'm not going to pull something for a DUI 10 years ago when we're discussing physical abuse and harassment. And it has to be a conviction for it really to matter to a judge, I think. Convictions are the hard point. Especially look at if it was pled down. So they may have been charged with that domestic battery, but it was pled down to a disorderly conduct as a plea. I wouldn't use that at any point in time then as a judicial notice. I also look at proximity of time. If he had a domestic battery 10 years ago and then he had nothing for 10 years and then he started up again, I think that's a pretty big length of time that I don't necessarily know if I would use it or not, or if the judge is really going to think it's that it carries that much weight. And like I said, the crimes I would really be looking at are violent crimes: domestic battery, aggravated battery, sexual assault, crimes that involve weapons, anything like that. When developing your petitioner's testimony, I tend to think you have to approach it a little bit differently than you would your regular clients. A lot of the time, or the majority of the time in court, it's going to be the first time they've seen their abuser since they've left them or fled from them, or since the abuser was arrested and put in jail for whatever happened that caused you to be there that day. So she or he is going to be a basket of nerves and a lot of emotions. So getting up there, they freeze, they panic, they'll cry. So I start easy. You get your jurisdiction and your foundation questions out, but I make them softballs and I make them last a little bit longer than you probably normally would have with a regular client, any other regular clients in any other kind of cases. I really break it down: where they live, county, how do you know the respondent, the relationship, when did you get married, when did you divorce, or when did you break up, or how long did you live together, do you have a lease, is he on the lease? Just softball stuff that really can answer off their brain without thinking, to get them in the groove of answering before I go to my evidentiary hearing part. Then I take one of two paths when I get to evidence. I take either the chronological flow from your allegations of your petition, if they all are around the same level of severity. If they're all around the same, then I'm just going to go chronologically, because it's easier for the court to follow along, and it's easier for the client to know this happened this, and then this happened next, and just move on to show your level of escalation. If you have a weaker petition, but it has one big incident, I get it out of the way right there, the first thing. So we set the tone for the court, like, this is what we've got. This is why we're here. This is what happened, and this is what we're going for. Then I may go to my weaker incidences and then followed up with a little bit of my stronger ones that wasn't as big as the biggest incident, kind of to overlap, to show like this has been an ongoing thing. This major thing happened and that's what ended us up here, but this has been going on for a while, to show the past history. Then a lot of courts, and I've seen in my experiences, the judges love when you save remedies for last so they can just write them all down. And I ask all these questions leading. I never ask the client to be like, and what would you like the court to order you today? Because then they're just going to go off on a tangent or they will miss something. I just ask them leading: are you requesting the court to grant you a 2-year, 500 feet stay away here today? And they can say yes. And I run through the remedies that we're requesting. The second to last question I always ask them is what the risk of future harm is without the order. I always ask them, would you fear for your safety if a 2-year plenary order of protection was not granted here today? And they say yes, and I say how or why. And it gives them the last chance moment to tell the judge like why I need this, why I want it, why it's pertinent that you order this today. And if they have children, they are including their children in there. I also ask them the follow-up question: would you fear for your children's safety if a 2-year order of protection were not to be entered today? And they can answer it that way also. Take it for what it's up to you if you would want repeat clients coming back or being pulled out of the courtroom. At Land of Lincoln, we always add in the miscellaneous remedies section, R17, that we have the client's permission to withdraw after 30 days from the entry of the order. just so we don't get pulled into a courtroom one random day because somebody's coming in to get a vacated order and we have no idea what's going on. Or we get a call from a clerk saying somebody's trying to file a petition to vacate their order or modify the order. What's going on? You're the counsel, you're the attorney of record, what's going on, and you have no idea. It kind of just, you leave the order with the client and it's up to them to hold on to it for that 2 years or do what they want for it, and they don't have to bring you back in. This case came down in 2018, Sternberg versus Brian B. I take this case with me every plenary hearing I have. Primarily if you're going up against opposing counsels who aren't as familiar with orders of protection. If your clients, you'll often, after you meet with them, most likely if it's a pro bono case from us, they will already have a petition filed and they will already have their EOP or been denied their EOP. So you're preparing for your plenary hearing. Most of the times you're going to meet with them and they're going to come up with other stuff that they didn't think to put in their petition. You're going to want to include in their testimony. Prior to this case, I would have amended their petition. And that can take some time, and orders of protection, I think everybody knows, is a quick turnaround usually. So there's not a lot of time to get that accomplished. So because of this case, I don't always amend the petition, and I actually don't amend very many petitions anymore. This case says that essentially that if the allegations that you want to bring up in testimony in your hearing are within the same nature of the allegations that were in the petition, then the respondent was essentially put on notice of what was going to be discussed in this hearing today. So if the allegations are all about respondent's physical or mental or emotional abuse to the petitioner, and she talks about something that happened that he did to her that's not in the petition, then I would not amend my petition and I would just have her testify to it. And then if it raises the objection, I present the case to the court and to opposing counsel, and I haven't had it been denied before. Now, if clients' allegations in her petition are all about her and respondent, and then she's in here and she's saying, when he also does this to the children, he does X, Y, and Z, I would then amend my petition because I think the allegations, including minor children or including a different party, would be a change in the nature of what to expect to come out in the hearing. Remedies for a plenary order protection. I'm not going to hit on these a ton because we have a limited amount of time here today. A couple things I just wanted to point out, and we'll discuss parental responsibilities here in a minute because I think those are a beast in their own. I'm very honest and very transparent with my clients about realistic expectation and realistic remedies that they could achieve. It's not that they're not entitled to those or that the court can't order them, but are you going to get them accomplished? For example, money. If they want hospital bills reimbursed and they want property damage reimbursed and lost earnings, etc., but we know respondent hasn't been employed, isn't employed, and hasn't been employed for years, what are the odds of you collecting on that money? Where are you going to get it? Same with counseling and treatment. I know in my area, I would love to get abusers to go to counseling, especially if we know they're a drug abuser, et cetera, to require them to go to some type of counseling or treatment. But the options here are just not available. Where am I going to send them? And I've had judges say that I would love to order this right now, but I don't know where I'm going to send them. I mean, the other possibility is doing the same mental health or drug evaluation you would do in a criminal case, but it's self-reporting, and I don't know how much productivity that would actually do for the client. FOID cards and firearms. I also tell my clients if there's no allegations regarding firearms or weapons, it's harder to get that taken away regardless if you're getting the order of protection and you're entitled to ask for it. I'll put it on there, but often and not, if there's no allegations including weapons, they're probably going to get to keep their FOID card. The Illinois Safe Homes Act, I've included the link here to the actual act. I'm not going to get to it in depth, but I include a copy of this with my clients after I get them in their order of protection. This allows victims of domestic violence and sexual assault to get out of their leases if they share a lease with their abuser. They need to give written notice 3 days either within or prior to vacating the property. And it also gives notice that the landlord needs to change their locks if it's the respondent that needs to be vacated and removed from the lease for that to take place. The big thing is it doesn't prevent a civil suit from being filed. So if there was past due rent, the client was behind on her rent prior to her giving notice, the landlord can still go after her for that past due rent. This comes with my smaller landlords, not your big corporate landlords or business landlords, of people who just own second properties and rent them out. Usually are not familiar with the Safe Homes Act. So when I send a client with the act in their order to go get out of their lease or get their locks changed and they try to say, no, I don't have to do that, it's usually just a nice quick call from their attorney, and usually it happens pretty quickly. I've never had to actually take any type of legal action, but once they actually get a call from the attorney, things start to move along. Big caveat also, though, that this act does not apply to public housing. URBA and other sources of public housing have their own set of rules. So if it's a pro bono case, you want to make sure their clients that they are not living in public housing if you're going to give them this. Parental responsibilities is a huge thing, I think, in order of protection that I see most often. I'm going to make the disclaimer that you know your counties and you know your judges better than I do or anyone else. So you do what you know works in your counties. These are just things that I've seen and I've experienced that have been working with clients when children are involved. Because most often not, your client's most important thing when they have children is they don't want the abuser to see the children. That's their main priority, that they want to keep them safe and they want to avoid that. But I think protective orders are getting a bad rap. I think they are getting the interpretation that people are filing protective orders just to get children back or to get a leg up in another kind of family or divorce case. And I think it's getting harder and harder to just get an outright denial of parenting time without any type of extreme violence or a risk of the respondent disappearing with the children. So when I get a client and they express that that's their big priority, I ask them if they're married, if they have children and they are married, but was the child born before the marriage? Is there any pending F or D cases? And if there has been a voluntary acknowledgement of paternity filed. If the answer is no to those, then I would suggest not putting the children on the order at all. Because if he has not been established the father legally, then she has complete control, and if the child wasn't born during the marriage, then he's not the assumed father. Then I would not put them on the order. And I would safety plan with them, because then you can make the argument to the judge, Your Honor, we're not listing them as a protected party in this order, and we're not asking them as a remedy. I think there's another type of case that would be a more appropriate venue for the respondent to request that time and have that matter dealt with. Kind of gives the judge the out from having to deal with temporary parenting or out orders, just because we all know they're a temporary Band-Aid to something that needs to be permanently fixed in a family or a divorce case. If I choose this route, I always discuss safety planning with the client for when her children are not in her possession, and if she comes in contact with a police officer, if the respondent's trying to get the children. If the parties are married or not married, and there is a D or F case, and the client wants the children on the order, or I agree that I think it's important that they be included in the order as protected parties. The fact that there's a D or F case, I always take judicial notice of it and get it aware from the judge. And then in my closing argument and in my client's remedy section, when she's requesting on the stand, I always make a point to pull the attention to the judge that they're requesting to reserve the respondent's parenting time until it can be established in that appropriate D or F case. Again, it gives the judge the excuse not to deal with temporary matters. Because a lot of times they'll come in and say, I just want to see my kids, I don't care about the order, and they're forced to try to figure out something temporary. And this kind of gives the court the out, and it saves your client. I always tell, don't do the work for the respondent. Don't open the case for them. Make them get the attorney, make them pay the retainer fee to go file and ask for their parenting time. Don't do it for them. or make them go to the clerk's office, make them fill out the petition requesting the time, make them pay that filing fee to request further parental responsibilities. With child support, I ask them to be practical about it. If there's no F or D case, I advise the client if she really wants it to apply to the Attorney General's office or DHS, but to think about, what does she want more, uninterrupted time with her children or child support? Because odds are you take them to child support case, they're going to say, well, if I'm paying for that child, I want to see that child, and boom, you're going to mediation and trying to work out a parenting plan. Supervised visits, make sure you always have your accompanying supervisor affidavit. If your supervisor can't come to court and tell the judge, I agree to be the supervisor. Also with our clients, if you take a pro bono case, always evaluate with the client if going forward with an order of protection may be in their best or not in their best interest. Because protective orders tend to trigger D or F cases, that may not be a great route for our client. They may have what it takes or the facts to get them their order of protection. They may qualify for an order of protection under the IDVA. They may deserve one, but they may not be in the best position to litigate a best interest of the children's factors case. A lot of times our clients have fled from their abusers, so they may be in shelter or they may be homeless and they're trying to get back on their feet. They may be employed because their abuser didn't allow them to work, so now they're trying to figure out an income. They may have criminal convictions that I'd like a little bit more space in between of rehabilitation and no new offenses to show the court that she can meet those best interest factors to become that primary parent. This is a caveat that I'm talking about your emotional harassment, abuse cases. I'm not talking your extreme violent orders or protection cases. I'm talking something that you think we can safety plan. The respondent doesn't know where she's living. She's got him blocked on everything. And there's really no way he can contact her. Then we may want to talk about her getting her ducks in a row. So if it comes a time that she's ready to litigate that family case, because it's eventually going to come. The orders and the acts all say that mutual no contact orders are prohibited. But for your weaker cases or your clients who have really different priorities, like they just want to get divorced and be done with this person, there is kind of a backdoor way of doing it that I've found that have worked for clients. So if there's a pending D or F case and your client really just wants to get divorced, they really want to get that parenting plan just figured out and they want the person to leave them alone while they get it figured out. If the other side will agree, I will enter a mutual no contact order and have it adopted in that D or F case and dismiss the OP without prejudice. I put the exact same kind of language in that as the OP order in that no contact order. That would essentially be no direct, indirect third party contact. If they have children, there may be a caveat that they can only communicate through text message or written communication that has to do with the respondent facilitating his parenting time and or emergency issues regarding the minor children, and that's it. Pro of doing it this way, I don't bring it up unless the other side brings it up, but time limits. If nobody brings up of when it's supposed to expire, I don't put it in there, and technically it sits there until it's vacated. That can be great for your client. That may be really appealing, but I always have to hone in that the possible consequences for violations are different. If you violate a mutual no contact order in a D or an F case, you have to follow a rule to show cause. Opposed if they had an order of protection and they called the police, then the respondent could be immediately arrested. There's just a bit of delay, but I always the caveat, if you're in danger, if you fear for your life or your safety, 911 is always an option. That's never not an option. If there's no pending D or F cases, you can still get a mutual no contact order for your client. I do this often when our client does not have a great case. There's not a lot of evidence. The allegations may be a bit weaker, but I think the parties need to leave each other alone and just move on, and this kind of ensures this happens. The other side would have to be in agreement, but I would file a petition requesting an adoption of an injunction of a no contact order in a miscellaneous remedies case. I would put in the petition the parties have agreed to X, Y, and Z, and then file the accompanying proposed order with all the terms of the no contact and include the signature for both parties, and both parties need to sign it. Same pros as the other way around, no time limit if nobody asks for a time limit, and the same ways of sources of reporting violations. Tips, the final thing I'm going to kind of cover is how to work with domestic violence victims and sexual assault victims. They are going to be very different than your regular clients sometimes, depending on how long the abuse was for, and the severity. It can be a lot of hand-holding. It can be a lot more attention than you may be used to giving some clients, just because they need that constant reassurance. Our clients usually have a lot going on in their life. This is not the only thing that's going on in their life, and it tends to be kind of chaotic. So to get them to focus is a big thing. Their range of emotions can change and change quickly. I see this most often in our first meeting when I'm discussing their case and the process. And I tell them the positive parts of their case and what could go well in their case. But then when I also discuss the negative parts of their case and what could go wrong in their case or could adversely affect them, when I get to those negative things, I see panic. They start to panic, they start to cut me off, and they start to go the opposite way. And I had to bring them back and say, I just have to tell you the good and the bad possibilities. Not telling you one is more likely to happen than the other, but I have to let you know so you can make an informed decision about your case. I also tell them, my clients, it's okay to be emotional. It's okay to cry. It's okay to cry on the stand, that everybody in the room understands that what they're doing is a big step and that it can be a scary thing, but they cannot get angry. It's the worst thing I can see to clients and their cases is when they get on that stand and they're being crossed by that respondent or that respondent's attorney and they have an attitude or they get angry, because I don't think the court or the people in the courtroom will understand where that anger is coming from. Our attorney may understand that, but the room doesn't understand that. And I think it can really be a detriment to their case. Also, victims tend not to trust coming forth with coming information at the very beginning. I always explain I'm on their side. I'm not afraid of the adverse, that I'm going to be their voice in court. I often have to ask the same question in multiple different ways. I have to ask it one way, they'll kind of give me an answer, I move on, but I come back and ask the same question in a different way and I get more information. I have to do this repeatedly multiple times, just because they don't trust you yet. They won't really trust anybody because they really haven't had help up until this point. I reassure them with our confidentiality, but I also, this is a point where I recognize a lot of victims don't trust our police departments. This may be for a slew of different reasons, but I tell them, if you're going to get this order of protection, the only way it's worth anything is if you report the violations. If you don't, we're going to report the violations, and all it is a piece of paper. So I really have to make sure that you hone in on that. We've already kind of discussed realistic expectations, and I make them extremely clear. You have to be very direct and clear with victims, just because they do live in chaos sometimes, or sometimes they just have a lot going on, and they can interpret gray areas differently. So being clear and direct is the best way to do it, along with their practical remedies. And also helping them understand that they're not the cause of their abuse. That's another big one, that their testimony in the court can come off very differently when they're rationalizing the abuser's behavior. But the biggest tip I would give anyone working with domestic violence victims is communication. They need a lot more communication than a lot of our other types of clients, just because it's such a high anxiety, high in stress type of case. If I know it's a client that's really going to struggle in that courtroom, it's really going to struggle to get through those testimony, if I can prepare as many testimony questions as possible that I know I'm going to ask her on the stand, I can give them to her beforehand so she knows what's coming her way. There's no surprises, right? Like, I'm not going to pull something out of my hat, with the caveat, I may ask you follow-up questions. These may change a little bit before the hearing. If you have the time to do it, I would highly suggest it, because it really takes a stressor point away from the client, and one less thing you have to worry about. I always call the day before the hearing and walk them through what to expect the next day. I'm going to meet you at this point, at this time. This is what we're going to do next. Then we're going to do this. We'll go in the courtroom. We're going to set up our stuff. You're going to sit in this chair. I walk them through the entire time we're going to be there. I always meet them around 15 to 30 minutes early, and I walk through it again with them again. I answer any questions they have or concerns, and I just reiterate that they can get through this, that I'm here to advocate for them and give them that confidence to go in that courtroom. Most importantly, I safety plan for them. So often, more often than not, our respondents are out on bond or bail or they don't have pending criminal charges. And so they're just going to walk into the court and we don't know when they're going to get there, where they're going to go, and what kind of mood they're going to be in. So if I have a suspecting issue that they're going to be a really aggressive respondent, I'm going to prep with my client in the jury room. And she's not going to see that abuser until she's into the courtroom. I'm going to safety plan from the minute she walks in. And if that means I need to get her escorted to her car by an officer when we leave, I'm going to make sure that happens too. So she is never alone the entire time we are in that courthouse. After it's over, and sometimes even before, I give these resources to our clients to help them to the goal to permanently maintain their independence from their abusers. I'm not going to run through all these, are kind of self-explanatory. If there's a pending criminal case, though, that the client is the victim of, I always make sure they file their victim of assertion rights in that criminal case. So they're always informed of what's going on in their case. Also, so they can potentially get some reimbursement for any type of damages that they suffered from the crime, along with the Illinois Crime Victims Compensation Fund. And lastly, I make sure that they may be lined up or have the resources to any counseling or mental health services to kind of help them rehabilitate and plan for future, to become more strong and independent and less likely to go back to their abusers. If you have any advocates involved in your cases, which you may if you do a pro bono case for Land of Lincoln, they're a great resource for that. They will almost already have them tapped in to group therapy sessions with other victims, etc. If you are curious, if you have any domestic violence agencies or sexual assault agencies in your area, I've included the websites here on this slide for domestic violence and sexual assault. If you go to those links, you put your zip code in, and it'll give you a list of all the agencies with such a mile perimeter that you put on it in the filter. And it'll give you all their information, address, email, phone number, and most of them all have 24-hour hotlines for clients to call at any point in time. That's all we're going to cover now. I know we went really quickly, I went really fast. This is my information. If you have any questions or concerns, feel free to reach out to me. Our legal service and referral service for clients, the 1-800 numbers at the top, and they can also apply online at illinoislegalaid.org. All right, Jessica, I think I got it all done.
Great. Thanks, Caitlin. I know there's a lot to cover. And of course, when you volunteer, there is additional support available to you wherever you are in the state, with Land of Lincoln, Prairie State, with PILI. We get these questions on Illinois Free Legal Answers, which is another pro bono option you can do and answer order of protection questions and help with orders of protection. So now we're going to turn to Kathy and Dave, and I'm going to spotlight them. There was a quick question. Is there a statute of limitations that's applicable in terms of when the incident took place?
So I can sure. Take a shot at that. There is not. There's nothing in the statute that says that the incident had to have occurred X number of days ago, X number of hours ago. When somebody's seeking an emergency order of protection, many judges look to when the most recent incident happened, and if it didn't happen within a fairly short period of time, are reluctant to enter an emergency order of protection. The statute defines emergency differently than that. It defines emergency as, if the other side had noticed, would that put you, the victim, at increased risk of harm? But practically speaking, in many instances, judges want to know that something happened more recently. As it relates to the question of how far back should a person go in a petition, how many years back when the incidents have occurred, because frequently incidents have occurred over a number of years. The statute requires the court to look at the history. So putting older incidents in can be very helpful. It just kind of depends on the circumstances and how many you're talking about. But the short answer is that there's no time limit on when these things had to have had occurred.
Great, thanks. That is helpful. So Kathy, do you want to tell us a little bit about what you're seeing in the northern part of the state and through your practice?
Yeah. First of all, I just thought, Caitlin, those were great practical tips that you gave. There was like so many of them and it was so well laid out. And so if I could just super quick add a few to what you said. And this also reflects a little bit of the practice that we see in Prairie State Legal Services, which again is our offices are kind of the top half of Illinois. One of the things I would encourage anybody who's doing any kind of work with victims is to take a really long look at the statute. There's a ton of information in there that can be used when you're prepping for a case, trying to figure out what it is that your client might be eligible for, the purposes that are listed in the statute in the Illinois Domestic Violence Act can be used pretty effectively in argument. It's a good statute and it provides for a lot of relief for our clients. And the more familiar you become with it, if you're going to do this kind of work, the better off you're going to be, I think. On the question of testimony and what kind of evidence you're going to have your client testify to, it's important. Caitlin talked a lot about the evidence that supports the safety issues. If your client is asked for other remedies besides the safety remedies, which I consider the stay away provision, the prohibition of abuse provisions, but if you're asking for exclusive possession of the home, if you're asking for possession of the children, physical care and possession of the children, if you are asking for child support, it's important to remember that the testimony that your client gives has to support those requests for relief. So you're going to have to ask those additional questions. The case of Sandberg versus Brian B., which was a case out of our McHenry office, was is really helpful because we do end up representing a lot of clients who filed their petition pro se, and not having to go back and amend those petitions to add additional allegations has been extremely helpful. The thing that you do want to be aware of is if there are remedies that your client wants that they didn't request in the petition, you do need to go back probably and amend the petition, because she didn't ask for it, she's probably not going to get it in the case. And the last thing I would say is, Caitlin mentioned doing agreed or mutual injunctive orders in an MR case. I would say that, and we have been successful, and I think this has been true throughout our practice area, in getting simply agreed injunctive orders in the order protection cases themselves. So we don't have to file an additional case in order to get that. I think that the statute supports that, and in the section that talks about the remedies in paragraph 17. And generally speaking, we've been able to convince the judges that if we are just allowing the emergency order to lapse, we're not dismissing the case, but we're entering by agreement a mutual injunctive order. The courts have allowed us to do that. So it's one less step that you and the client have to take potentially. Caitlin did mention also safety planning a lot throughout her presentation, which is great because at the end of the day, we do end up doing a lot of safety planning with our clients, and safety planning is always changing. If you are not familiar with this kind of work, generally speaking, as Caitlin said, our clients are connected with one of the domestic violence agencies and hopefully working with an advocate who also will do some of that safety planning with the client, which can be really helpful. And there's a lot of information kind of out in the internet world about safety planning that you could take a look at, but it can be really important for clients to think about what they might do if, and sometimes we walk through that process with them. And finally, COVID. And this we've seen again throughout our practice area, and it's probably been the same in the southern part of the state. Everybody's been stressed out by COVID, and I think it has exacerbated exponentially the issues and the difficulties that our clients are struggling with. First of all, for many of them, they ended up being in the same place with their abuser for months at a time without any options, or very few options. Even though the courts were open when everything else was shut down, that message was not clear. People didn't know what they were going to do. They didn't think that they could, throw out the abuser or ask that the abuser be removed because there was no place for that person to go. Law enforcement was very reluctant to arrest, very reluctant to remove. Courts, well, again, said that they were open to protective order cases. Sometimes that wasn't clear at all. In Kane County at the beginning of COVID, they had a big mobile command vehicle sitting right in front of the courthouse, keeping people out of the courthouse. Not something that would be easy for a victim to breach, even though in theory, the victim was able to go into the courthouse. So first of all, understand that our clients are even more stressed than usual. And that is manifesting itself in many, and this is what we've seen, is that they're angry at everybody and frustrated at everybody. And folks who perhaps would not have expressed that to us or at us in the past, it's coming out now. So it is a little bit more stressful for the attorneys to understand where it comes from, if that's kind of what happens. And the other thing is to understand what's going on in your courthouse. I've most recently in my job been working with attorneys in over our entire area. So I've been in Peoria, I've been in McHenry, I've been in Waukegan, I've been in Joliet, I've been in Kane County, I've been in Kendall and DeKalb, I've been kind of all over, and every single courthouse has different rules. Understanding what those rules are when you walk into the courtroom with a client or get ready to do a Zoom with a client can be really helpful to minimize the stress and the worry that Caitlin talked about. We aren't always going to be able to practice with the client in the courthouse because maybe it's closed, maybe it's not closed. Just understanding that and giving the client the heads up on whatever it is can be really, really helpful to clients. So that's what I got.
Great. Thanks so much for that. And then Dave, can you tell us why people should do these cases pro bono, what your experience has been? I know we're at time if people have to go, but we are recording this. So we want to make sure to get that perspective. And Maria, I just want to let you know, I see your question and we'll be sure to get you an answer. Even if you have to log off, I'll be sure to get you a response.
Thank you very much. I volunteer because my wife volunteers for everything. And I checked with my priest, I can't get to heaven on her coattails. There are no coattails. So I thought I'd volunteer, try to get to heaven after leading a rather lackluster spiritual life. When I volunteer here in Danville, if I make a half-hour court appearance, my half-hour investment is really a 2-hour investment in the land of Lincoln because they don't have to send an attorney over, taking 45 minutes, make the half-hour court appearance, and then drive all the way back. So we know Land of Lincoln does good work. We know they do it well. We know they have limited resources, and we know there's a lot of good work out there that needs done. So if I can save them some time, I thought this would be a good use of my time, which I have plenty of now that I've retired. Working with them has been a pleasure. All of the attorneys have been nice, the office staff, the law students, they've just been so kind and welcoming and helpful. It's a great experience. The cases are well screened. Since I retired and I've been doing this for a little over 2 years, there hasn't been one that I thought, oh man, what are we doing here? Each one of them has been, each petitioner has needed the relief that's been requested. And the judges here, sometimes, as Caitlin said, judges don't like these cases, but they've been very kind, they've been very patient, they've been very understanding, and we've had some luck. Where we haven't had luck, unfortunately, is bringing a resolution when there's a pending criminal case. The respondent's charged with domestic violence. He comes in, especially if he has an attorney. Well, Judge, my client has the Fifth Amendment right. I got one that the incidents occurred in July, late July. My client gets the order in August, and we're set for a hearing on the plenary next month. Why? Because the defendant has the Fifth Amendment right, Dave, not to testify. Well, they have that right, and they can exercise it, and that raises an adverse inference if they choose to exercise it, or they can waive it and testify. But it's not a shield against proceeding in an order of protection case. Our local judges seem to have a difficult time with that concept. So next month we have a hearing on a plenary order that, unfortunately the incidents occurred last July. I thought Caitlin made a great point about the risk of future harm. Mm-hmm. Judges seem to have trouble with the extension of the plenary order. I have two clients. The judge, they filed their pro se petitions to extend 2-year plenary orders of protection. The judge said, well, has anything happened at the first appearance? Has anything happened in the last 2 years? Well, no, Your Honor. Well, then I don't know why we're doing this. And they've already prejudged the case, not realizing that the respondent has been incommunicado in an institution, unable to bother these poor people. And then, I don't know if you folks have any trouble with DCFS, but in my legal career since 1976, I've always had trouble with DCFS. They're never there when you need them, and when you don't need them, they're sure to be there. So I'm not betraying any confidences. This is all in the pleadings and what opposing counsels told me. The sexual abuser, who's the respondent, when the mothers try to extend this 2-year order of protection, the abuser's a ward of DCFS, and they hire an attorney to prevent the entry of an order protecting his victims. So I'm puzzled by this, but that's why it's fun to do it. You can get worked up about it. My wife, when she volunteers for something, she comes home, she's always worked up about a cause, and that keeps me young. And getting worked up about stuff that DCFS does, things that people do to other people that are incorrect, that helps keep you young. So I really want to thank the Land of Lincoln for giving me something to do and for their help in doing it. And, they do great work. Thanks.
Thank you, Dave, and thanks for taking those cases. One last question I'll throw to anyone in the chat. Are there suggestions for pro se plaintiffs who cannot bring witnesses to the hearing? Is an affidavit sufficient?
An affidavit's probably not going to be sufficient. And these days where we have all become used to doing things via Zoom, one thing to do would be to request to have that person testify via Zoom, even if you yourself are on an in-person hearing. It's obviously up to the judge, but that is an option that seems more viable now than perhaps has been in the past. Those are my thoughts on it. Caitlin, I don't know if you have any additional thoughts.
No, I agree. I've had a couple extreme circumstances when maybe somebody's been in a hospital that a judge has allowed them to testify over the phone, very limitedly, but it's had to be a pretty extreme situation. That the judges usually say, I can't look at that piece of paper, or I can't see that letter or that affidavit, that's hearsay. They need to be in here to testify for themselves.
Great. Well, thanks everyone. And thanks for staying over a little extra. We appreciate your time and attention. A huge thank you to Caitlin and Kathy and Dave for joining us today. And I know at least a couple people have said they're willing to be an unofficial mentor or consultant on these cases. So I might hold them to that. If you needed a little extra help in volunteering, please consider getting involved. I know most of you committed to something when you signed up for the CLE, so I'll be following up with you on that. and the pro bono opportunity. And then please stay tuned. March 30th will be our next one in the series, and it will be about mediation and a focus on evictions, with the thought that the moratorium will likely be ending at some point. But I really appreciate everyone joining us and taking the time, and have a great rest of your day.